Hi everyone, it's a real pleasure to be here with you today to talk about what is a super interesting topic. I hope you'll agree at the end of this presentation. So my name is Sarah Jane Dobson. I am a partner at Kennedy's law firm where I specialise in international products law, which basically means all day, every day, I look at three different aspects: product safety, product compliance, and product liability. And my team and I help companies to navigate the product life cycle. So starting all from the beginning of the product life cycle all the way through to any sort of liability issues that might arise on the other end, including class actions. So today, as I said, we're talking about a topic that is a big one, ESG, and more specifically green claims and greenwashing. So basically, this topic is one that is I think we can all say something that pops up in daily newspapers and makes headlines almost every day. It used to be that this topic, or the notion of ESG in terms of regulatory compliance, was perhaps nice to have, or something that was considered to be a positive PR exercise. Those days are really gone now, and what we're seeing is a move from something that's a hypothetical nice to have that has been talked about for a long time in policy departments, and we're moving away from that now into something that is a hard mainstay requirement in terms of compliance. When we talk about greenwashing and green claims in the context of product safety more broadly, I would say that there are three ways in which these types of obligations are cropping up. First and foremost, there's some pre-existing obligations that exist in mainstay product safety regulations, which include the cosmetic products regulation as well. There's also a proliferation of specific regulations that are specific to products that have ESG as their main imperative. So, for example, outside of the cosmetics realm, but things like the Conflicts Mineral Act and those types of regulations that are new or newer that are specifically with that aim. And then we have a third type of regulation that are across sector and really look at things like due diligence and sustainability. And I think it's a testament, because usually I'd start this presentation by explaining perhaps what ESG was, or even perhaps describing what green claims or greenwashing are. But we've come to a stage where I probably don't even need to do that. I think almost everyone in here will know what that means. But essentially we're talking about product claims that have an environmental basis that might be used to mislead consumers or induce them into purchasing products. So what I hope to do in this 30-minute whistle-stop tour is to really take you through some of the more legal framework pieces of how this works. So we'll start by talking about the general applicable legal framework for these types of environmental products claims, some of the sector-specific regulations, cosmetics being one of the industries that has been particularly focused on by regulators across quite some time now. What I describe as the safety net regulations, which I think probably most of you would be a little less familiar with because they are completely outside the product regime and completely outside the cosmetics regimes. These are more general legal frameworks. Then we will look at some self-regulating codes and principles and some other sorts of guidance that may be applicable. I think most of you will be familiar with these as well. We'll turn to some policy considerations, both at EU and UK level, and we'll also look, more importantly, I think, at some practical examples of what's been found to be in breach of these types of requirements for not making greenwashing claims. And then we'll close with some tips to combat greenwashing from a practical perspective. So as I said, the cosmetics industry actually, and you may not be aware because it may be that you don't contrast it with other regimes, but in fact the cosmetics regulation is one of the most highly regulated in respect of making product claims. Not very many other product safety regimes have inbuilt in their regulation this specific requirements for substantiation of claims in quite the same way as cosmetics does. But as you'll all be aware, there's two main sources of those regulations, which I'll come on to speak in more detail on shortly. As I said, there's then another layer of regulation, which I describe as the safety net regulations. And by that, I mean, as we know as a general principle for legal requirements, you look to the most specific legislation first, in this instance, the cosmetics regulation and the common criteria regulation. And if there's an absence there or a silence there, then you look to more general regulations. And these are really the Unfair Commercial Practices Directive and the Misleading Comparative Advertising Directive, the Consumer Protection from Unfair Trading regulations being the UK implementation of the first. As I said, those are more general consumer regulations, and they are really big news at the moment. They're used in all the class actions that you would have seen generally, and they are quite favoured amongst claimant law firms currently as a way of bringing litigation against bigger companies or smaller companies. And then we'll look at some of the guidance documents, which sit in an interesting space, I know for many of you, because they tend to be non-binding, non-legally binding pieces of information that are meant to be useful, which they are often useful, but it does make it tricky when you're faced with litigation or you're having to answer a regulator, because of course there's no obligation for you to follow these guidance documents, but it does put you in a slightly uncomfortable position if you have not. So we'll talk about those in a bit more detail. So in terms of the requirements for cosmetics specifically, starting with the sector-specific regulations, which, as I said, is the best place to start generally. So Article 20 of the cosmetics regulation, as we all know, has a pretty broad requirement, which simply requires, in very brief terms, that you substantiate any sorts of claims you make. So this isn't specific to greenwashing, as we know, but it does extend to things that aren't just words. It talks about pictures and it talks about labeling, and I think that's an important thing to take into consideration when we're looking at advertising. We actually mean the product claims being made on our products as well, not just online marketing or ad campaigns themselves. In terms of other regulations that's relevant, all of you will be very familiar, I'm sure, with these general common criteria, which are, as I said, a specific piece of regulation unique to cosmetics. I think the nutritional supplements regime has similar requirements, but actually this is a requirement that is quite unique to cosmetics industry, and therefore in some ways makes it both easier and harder to comply with these requirements. But essentially there's 6 common criteria. As I said, many of you will be familiar with them. Essentially, it's required that there's legal compliance, which essentially means that you can't allege something is compliant if in fact it's just speaking to a mandatory requirement. So for example, if you say it's not tested on animals, well, nothing can be tested on animals in the EU. So that would be an example of breaching that. Truthfulness is obviously, as it says on the tin, you need to make sure that your claims are truthful and are not generally misleading. They need to be backed up by support. They need to be honest, which usually means that you cannot extend what you're saying to something that is outside the realm of what's supported by your evidence. They also need to be fair, and that really speaks to, as we'll come on to later, actually making comparative claims. So generally you can't be seen to be denigrating your competition, or in fact suggesting that a legally permissible ingredient is somehow not permissible. So outside of the green claim space, that fairness criteria has been quite focused upon recently, because a lot of competitors are sort of trying to nudge out the competition by suggesting an ingredient that's being used is somehow unsafe or unlawful based on the claims that they make. And essentially, really, which I think is the gist of all of these requirements, is that the purpose of these criteria and these frameworks generally is to make sure that consumers are given enough information to have an informed decision. So they need to have the facts to hand to decide whether they're going to buy this product. And really that's the gist, as we'll come on to, for the more general for the more general regulations as well. So these safety net regulations, really, these are consumer protection laws. And as I said, if I think about it, most of the last class actions in recent years have been, in particular in the UK, under that middle regulation here. What the courts are concerned with is making sure that consumers are informed, aware, and have the choice to be able to purchase a product or not. So the gist of all of these regulations goes to giving people that freedom by setting out information in a factual way and making sure we're not misleading them. But they do go a lot further than that in many other ways. So, for example, the UCPD, which is the Unfair Commercial Practices Directive at an EU level, whilst it doesn't really contain specific requirements for green claims or environmental claims, it certainly has a very comprehensive list of things you can and cannot do, particularly in Annex 1 of that regulation, about misleading consumers. It also just generally, I think it's fair to say, puts a pretty high onus on ensuring that you are fair and are transparent with consumers. The CPUTR, which is the one I mentioned in the middle, is actually just the UK's implementation of the EU regulation you see to the left, which post-Brexit has already been enforced. So watch this space to see if there's any developments, but so far it stays in place. And as I said, more and more those two regulations are being used than they have been ever before. And the Misleading and Comparative Advertising Directive was aimed originally to be business to business only, but it does have some teeth in respect of business to consumer. But I think it's worth remembering that your misleading claims are actionable, not only in respect of your consumer marketing, but also as it relates to a competitor. And that's, I think, a quite new development, and I haven't seen that act on the right be relied on as much in litigation. But given the focus on not denigrating competitors rather, and also this focus on the types of claims that are being made currently, I think we will probably see in the future more claims being made in the right-hand piece, which has a slightly narrower scope for the reason that I said. So sitting on top of all of that, we have a series, as I said, of non-legally binding is the word that they always use in all of these guidance documents. And I think the first important one is the technical decision that's made by the European Commission. You'll all know that it goes in painstaking detail and looks at all of the different 6 criteria that I've just mentioned and sets that out in quite some detail, arguably based on studies that have been done by the European Commission that look at the types of claims that are being used and how they might be misleading customers and consumers. And what we have also at an EU level is the International Chamber of Commerce's Advertising and Marketing Communications Code. And you can see they also have a criteria that they follow. And what I would say is that there looks to be quite a lot of overlap between a lot of these criteria. But as I always say too, you have to play to the audience in which you are marketing the product. So although it's subtle, you can see there's slightly different leanings of each of these codes and each of these different pieces of regulation. And to the extent that you're marketing a product in a certain country, I still think that you should take the time to read and consider those requirements, because usually they will tell you what are the preferences and priorities of the regulators or the legislators that you are dealing with in that particular jurisdiction. So for the EU and the general guide that they provide in this respect, it is, like I said, quite a lot of overlap, but essentially it requires these criteria here: honest and truthful presentation, which you'll remember does have resonance with the honesty criteria that you remember and the truthfulness criteria from the common criteria from the cosmetics regime. Scientific research, it specifically calls it out in this particular criteria. You'll remember that substantiation is a requirement under the other criteria, but it specifically references scientific research in this instance. Superiority and comparative claims, which, as I said before, is a feature of the regulations for cosmetics, but this expressly calls it out. And then an aspect that, because this is a slightly newer code, I would say is actually more at the forefront now than it has been ever before, and that is considering the product life cycle. When I come on to the examples, you'll see that it's no longer good enough to just talk about one aspect of the product life cycle and make a claim that you're confident about for that aspect. You have to be considering the full life cycle of your product when you're making green claims, because something that might reduce CO2 at the beginning of the life cycle may not do so by the end. So you do need to be considering that. And the fact that that's expressly been included in this ICC code, I think, is indicative of a crackdown on claims that don't hold true for the full product life cycle. And as I said before, signs and symbols. This is relevant also because I'm sure you'll all be aware of all the conflicting types of green dots and recycling symbols and bins that you can use for displaying recyclability and environmental friendliness throughout Europe. Frankly, the regimes that dictate those for actual symbols are already a mess. It's hard. It's one of the areas where it's not particularly harmonized at an EU level. And just to add some salt to the wound, this advertising code requires you to very carefully consider those types of signs and symbols. So in other words, if you have something on your product that is meant to be a symbol for a certain jurisdiction in Europe that suggests it's recyclable or somehow has environmental friendly features, and that could be misleading to an audience in a different jurisdiction, so the green dot from France is a good example of that, that really can come back to bite you. So it may be these days that it's not appropriate to have a packaging with symbols on it for recyclability or environmental purposes across the whole of Europe. And I have seen regulators clamp down on that in practice, and it is something that is ripe for confusing consumers. So I don't think it should be overlooked. A tiny symbol on your package might seem inconsequential, but that isn't the case. And then again, harping back to sort of the product life cycle in full, how you're handling your waste. And I think when I was speaking yesterday, I was talking about the fact that the cosmetics industry, again, has arguably been targeted in respect of, extended producer responsibility and take-back requirements more than perhaps other industries. So again, this waste handling aspect has a big impact on cosmetics industry in so much as what you do with the product when it's done and what claims are you making in that regard. And if, for example, you have a take-back program or you have something in place, if people aren't complying with it, clearly the claims you're making about being environmentally friendly can't be true. So you just have to think through the practicalities of making those types of claims when it involves the consumer as well, because it will not be accurate if it's not being followed. So then many of you here in the UK will be aware of the Advertising Standard Agency's BCAP and CCAP code. So essentially that relates to broadcasting and non-broadcasting. Again, it is quite prescriptive. It does have specific codes that apply not only to beauty and cosmetic products, but also in respect of green claims and greenwashing. And I would just pause here to say it does matter about broadcasting claims, because I know as an industry it tends to be that people focus on the packaging and the written words, but saying things on TV and even social influencers and endorsements from celebrities are still equally subject to these claims. So unfortunately, just because you're famous, you don't get a rain check to say something about the product that may not be true. So these codes are regularly enforced. As I said, it's a tricky position to be in where something is technically non-legally binding, but you find yourself at the other end of a decision that's adverse. And we'll come on to that in terms of practical tips, because I appreciate that's one of the most complex things to navigate for people in real time. But essentially, in terms of other principles and guidances that are coming out, I mentioned again yesterday that there is a new involvement, arguably, of the Competition and Markets Authority, the CMA in the UK. And that is particularly relevant because many of you will be aware that usually the Competition and Markets Authority and the product safety regulators really stay in different lanes. The product safety regulators are more involved in discrete issues and are interested in discrete problems in the market. The Competition Markets Authority is involved in systemic issues. So the fact that the Competition Markets Authority is making a green claims code suggests that it's now risen to a systemic issue and it's an industry-wide issue. What it also means, unfortunately, is that there's a different enforcement profile. So the CMA have much more teeth, arguably, than the ASA or the product safety regulators. Generally speaking, product safety regulators have quite a broad range of powers, as you'll all be aware. They have powers of inspection, powers of requesting documents, they have powers to withdraw products, powers to make you destroy products, or in some circumstances, not let you sell products in the future. Of course, there's also financial sanctions for product safety regulators, which depends on which jurisdiction in Europe you're in. But of course, there can be unlimited sanctions, financial sanctions for product safety regulators. And often there's criminal sanctions, which means someone can go to prison. Often in Europe, again, it depends on the jurisdiction, but up to 3 years is not uncommon. So there are some real significant enforcement powers already with product safety regulators. But for the CMA, we have much bigger enforcement powers. Up to 20% of global revenue and turnover of a company can actually be the fine that you receive. So it is an incredibly huge financial exposure that you have. So, as I said, this, I think, marks the beginning of a more systemic crackdown on these types of issues by a regulator that has, at least financially, in terms of financial exposure, more power to enforce sanctions in that regard. The actual criteria itself are not so dissimilar to what we've seen before. Claims have to be truthful and accurate. They have to be clear and ambiguous. They can't hide or omit. And I think this is a particularly interesting one because that actually is different from any other code. As a lawyer, it's always interesting because I think when I was early in law school, one of the first quotes I remember hearing is that it's the sin of omission which lays eggs under your skin. So it's true, actually. Up until now, nobody has worried so much about what you're not saying. But I actually think in many instances that's more liable to confuse and mislead people by not saying things. So it's quite interesting the CMA has picked up on that and no other regulator or code has. You have to compare goods in a fair and meaningful way. Again, that goes to the competitor point. And you need to consider the full life cycle of the product. Again, this is quite a repetitious point now between the ICC and the CMA, but as I said, as you saw from the earlier versions, that wasn't actually a feature of the regulation, so we are seeing a change. And of course, as always, the claims have to be substantiated. So the topic of greenwashing, green claims, cosmetic claims generally really has been on the radar for quite a long time. As early as 2015, the European Commission did a study into cosmetics claims, and they noted that most consumers found it difficult to understand which products were actually environmentally friendly. They also looked at actual claims on the market, and many of them seemed to fail the criteria in terms of accuracy and clarity, and many contained actually untruthful statements. So those were, in some ways, the early findings and early beginnings of what was a quite focused approach in respect of cosmetics and green claims generally. In 2019, the European Commission, as we all know, launched the Green Deal, which was a whole raft of legislative initiatives which really had at their core this focus on ESG and environmental concerns. And in that policy, there was a lot of mention of green claims or greenwashing being stamped out, so it's definitely high on the agenda of legislatures and regulators. As you can see, since then, there's been quite a lot of developments. The EU Circular Economy Plan, which I think speaks more to the aspect that I've mentioned that's being introduced over time, looking at the full product life cycle rather than just looking at a discrete point in time and making a claim. The CMA, as I've just said, has got involved since early this year. There's also been some proposals in respect of specific greenwashing issues. And as I said, there's also some suggestion of even more enforcement powers for consumer protection laws. I would also say that laws are generally only as powerful as they are enforced or used by claimant law firms. So the fact that these consumer protection laws are being used more and more, I think, is something that people should be aware of, because clearly it increases the risk profile for companies. It's all well and good to have a law, but if it's not being used, then arguably it's not as effective as it is when it's actually being enforced and relied upon by claimant law firms. And in July 2022, as you'll all be aware, it's not quite in the cosmetics realm, but it is in the fashion industry. You'll all be aware there are some very significant findings by the Competition Markets Authority in respect of some fashion brands who had been found to fall particularly foul of greenwashing claims. So what are some real life examples? I'm taking some examples from the ASA, the UK Advertising Authority, because they have quite a few interesting findings. So just to take you through a few examples of those. Strangely, most of them, not very many of them refer to cosmetics. There is a one against Coty that is not in respect of environmental claims, so I haven't included it here today. But interestingly, generally speaking, there aren't that many generally that have been found against cosmetics companies. There seems to be a lot of focus on the food industry, and also to do with, as you'll see, packaging generally. So before I go into that the types of claims you might see actually that are relevant to these types of issues, there are quite a few. So natural and organic claims are some types of claims that obviously are thought to be liable to be particularly misleading and fall foul of the criteria. I think you would have heard from other speakers about ISO standards that are applicable that might help you in that regard. The claim about not tested on animals probably goes more to the S than the E in this instance, but of ESG. But essentially, obviously, given, as I mentioned, the ban on animal testing and marketing, that's not really a relevant or appropriate claim to make for consumers in the EU. Environmentally friendly claims, a very broad claim like ocean friendly or more environmentally friendly, which is a comparative claim, are some of the claims that are proliferating currently. As I said, claims referring to packaging and recyclability and biodegradability. That, in particular, the focus on full product life cycle is quite important. And then claims on microplastics and microbeads, saying things like plastic-free or free from microplastics. Those types of claims, again, are ones that are generally found to fall foul, depending on the particular regulatory environment that you find yourself in Europe. So for some particular examples, the first one we have is to do with a ruling against Oatly. And you'll notice the timing of these rulings are quite interesting because they're all often within this year. So January 2022. And just for everyone's information, the ASA obviously makes a ruling, and in some respects, that's the power that they have, and that's all they can do. But frankly, for a brand that relies on reputation, that's bad enough as it is. And as I said, those 3 fashion brands before, you'll all be aware of those adverse findings against them. So it does apply quite a bit of pressure. And often the ASA and the product safety regulators and now the CMA do get involved. So you might have a triple effect of these types of rulings. So whilst admittedly the ASA doesn't have as strong a power to enforce, often this negative publicity is more than enough to be a problem for companies. So the Oatly claims were making claims that their products were green or environmentally friendly, and they specifically went on to make relative claims to say that they're greener or environmentally friendlier. And essentially there was a series of claims, and you'll see how generic they are and how much you can get in trouble for making generic claims. So it says things like Oatly generates 73% less carbon dioxide than normal milk. The dairy and meat industries emit more carbon dioxide than all the world's planes, trains, cars, and boats. Today, more than 25% of the world's greenhouse gases are generated by the food industry. And climate experts say cutting dairy and meat products from our diets is the single biggest lifestyle change we can make to reduce our environmental impact. So those are really quite broad claims, to be honest, and interesting for a milk manufacturer to be make such broad claims about our lifestyle. But needless to say, the ASA ruled against them on the basis that the comparisons and percentages were too vague. The absolute claims didn't consider the full product life cycle. And if the claim only relates to specific products, it cannot be so generic as to seem to apply to a whole host of products and or environmental and or lifestyle choices, which clearly, as I said, was the case here. It also was found that the general scientific claims must be the scientific consensus and can't simply just be one person's opinion, because when they dug into the substantiation, it was found that actually much of those statements were based on one person's opinion, which just clearly isn't enough to make such broad statements. Similarly, in January 2022, another absolute claim or 100% recycled claim from a water bottle brand, which claimed that their water bottle and cap were environmentally friendly and recyclable, when in fact it was only the bottle itself and the cap that attached to it was not able to be recycled. Some semantic arguments were made by the company to say that because the cap was attached to the bottle, it couldn't get off and couldn't fall off and actually cause problem in the environment, and it would have been disposed of at the same time as the bottle. Needless to say, that didn't work, and a ruling was made against them. Pepsi in January 2022 also, as I said, you can see there's a theme that there's quite a lot of decisions at this time. They again made a 100% recycled claim, and again it was to do with the fact that their bottles versus their caps had different recyclability profiles, and they were making generic claims that extended to them. The Alpro finding in respect of almond milk, another milk alternative, making products such as good for the planet, were too ambiguous and were not considered to be able to be substantiated, and also didn't take into account the full life cycle of the product. So as I said, that is one of the hot topics for this moment. And probably slightly closer to home is Unilever. In August 2022, it says, kinder to our planet was the contentious environmental claim here, which was thought to be a comparative claim and therefore was not fair to competitors because not enough information was given to customers to make that comparison, and nor was any information actually provided or substantiation provided as to how they made that relative assessment. So you can see that there are a proliferation. These are just a handful. I could go on for a long time about all of the examples of these types of claim. They are really specific to each fact. So you do really have to think through. So in terms of how to avoid being these companies that are being called out for their greenwashing claims, you really need to know your product very, very well from inside out and from the full product life cycle, and really try to understand from a scientific perspective how that impacts the environment, and really think about what types of claims are both useful to allow consumers to make a choice and also are truthful and accurate and able to be fully proven. Know the complex regimes. I think more than that, I would know which regimes apply when and what perhaps is legally binding versus not legally binding. My general recommendation, to the extent possible, is to follow any non-legally binding guidance in the country in which you operate, for the obvious reason that if you get called up by a regulator or if you find yourself in a witness box in courtroom, it's going to be much easier for you to say I did more than I had to than for you to say there was this non-legally binding guidance that I didn't follow, because obviously that's a little bit harder position to row back from. I would usually say go further if you can than the non-legally binding guidance as well. So consider all of the guidance that I've mentioned before. Make sure that you have facts that really are substantiated across the full product life cycle. If you can use an external consultant, technical expert party, do use them. It's much easier, again, to substantiate your claims if it's not someone within your company. It's an unfortunate fact that regulators and courts tend to trust substantiation that comes from outside of the organisation, which makes sense. And if you are going to deal with comparative claims, that is a particularly difficult area to substantiate. So you will have to have some actual testing, I would say, to back up those types of claims that you're making. Again, if there's an external party that you can use, that's even better. And again, think about where these claims are being made, whether it's through social media, whether it's on broadcast, non-broadcast, but also the prominence in respect of your marketing campaign generally, because clearly something that's in huge bright letters in the middle of your advertising campaign is likely to be something that's going to induce a consumer to purchase something. And that is the legal test in those secondary types of safety net regulations. It has to be a claim that has induced a purchase. So if you can mitigate that aspect of saying that it actually wasn't prominent enough, or it was too small, or it was a subplot to my main advertising campaign, that's something that makes life a little bit easier on the other end of the litigation profile. So I think my time's up now. Hopefully that was a useful whistle-stop tour, and thanks very much.